Hello everyone, so welcome to a session on contract law. So this is going to be about communicating acceptance. So if there's been an offer and there's been an agreement, so an acceptance, then we have agreement until the contract has been formed. So what's the next thing is, so usually the acceptance isn't valid until it's been communicated to the offeror. This is sometimes people put it this way, you can't accept through silence. That was held in House and Brindley. Anyway, but there are exceptions to that general rule. Okay, so remember, one party could, of his own free will, assume an obligation, which enables the other party to force a contract upon someone who doesn't want it. Okay, so usually silence won't operate. There are times when silence does count as an acceptance. Okay, but that's not. It won't be an acceptance if that imposes a contract on an unwilling party. There was Rust against Abbey Life, 1979, and the Court of Appeal had to consider this case, and they said obiter dicta that it broadly speaking approved of the silence as acceptance rule. Okay. So a contract offer can be revoked. Then another thing is you can communicate by various means, by telephone, by email, fax, and so on. Sometimes this is out of office hours, so that's tricky. There was a Tenex steamship company against owners of the vessel Brimners, a 1975 case. And here it was about ship charter and that being withdrawn. So if you communicate to an unmanned receptor like a computer or to a phone, then when is the communication received? We assume it's received when it's a reasonable expect to be checked, as in sort of 9 o'clock in the morning on a working day. If it's received in the middle of the night, then we assume that doesn't count as received at that time, bearing in mind time zones, in accordance with the working hours of that country, because of course office hours in Japan are different from office hours in Ireland, for example. Even if it's 9 to 5, we're talking about the Japanese time zone. Okay, so when is there no need for communication? Because there are a few limited circumstances in which that's not needed. For example, sometimes the offerer will have waived any requirement for communication. Carlyle and Carbolic Smokeball being the leading case on that one. That's about unilateral offer, and there being no need to communicate it. So unilateral offer is when one party makes an offer to another and says to asking the other to do something, or indeed to desist from doing something, and that other party doesn't need to communicate that they've done it, that they've accepted it. Sorry, they just need to do it and then communicate. Because 1839 Carlyle versus Carbolic Smokeball, remember that's the advertisement about a certain smoke ball. If you hire this, then you buy this, then you won't get a cold, and if we're wrong, we'll pay you loads of money. We've deposited £1,000 or something in the bank to pay out if there are any claims. So the need for communication was waived because that wouldn't be reasonable. The offerer had to rely on an absence of communication, would have been unnecessary. Okay, and then there's the postal acceptance rule, because remember, until the late 20th century, doing things by post was the main way we accepted and communicated offers. Telephones were only sort of almost universal, even somewhere like the UK in the 1970s. So loads of things were done by post. And remember, post was much, much slower until the 20th century. Things, even within the UK, things could take days. So a letter of acceptance might take a long time to arrive. When is the acceptance valid? And do we have to wait for the offeror to receive the letter? And we don't know when that is going to be. So generally speaking, as soon as it's posted, it's been received. We assume that way, because also you can get some sort of document certifying that you did post at such and such a time. So there's an exception to the postal acceptance rule. Anyway, Adams and Linsell is a case about that. Household Fire and Carriage Accident Insurance Company Limited against Grant, 1879, is a case about that. So the postal acceptance rule shows that there's a risk of delay, and that's up to the offerer he has to bear that risk. And remember, that's an exception to the ordinary rule whereby you must have effective communication for the contract to be formed. But remember, the postal acceptance rule only operates under certain situations. If it's reasonably contemplated by the parties, or indeed it's stipulated by the offeror. That was held in Household Fire Insurance against Grant, 1879. So sometimes the post was the only way you could communicate, such as in Henthorne against Fraser, 1892. But those days are long over when the post was the only way to communicate. Anyway, so the offeror has to take the risk, which is that the post will be late, as it sometimes is, but not by the carelessness of the offeree. And that's in LJ Corbetus, as in Transgrain Shipping BV. For example, the offeree got his address slightly wrong or something. Well, that doesn't come back on the offeror if that causes an undue delay. So now there are some tricky questions around these. So what if the contract is formed without the offerer knowing it's been formed? So the offerer makes an offer, and then the offeree accepts. The offerer then decides to revoke that offer before he receives the postal acceptance. So what happens? So he's got an offer from a third party. Okay, so this is tricky. And also technology has moved on. So the courts have had to find ways of dealing with this. There was Holwell Securities against Hughes in 1974. In that case, the postal acceptance rule was held to be disapplied because the offerer did not want it to apply. So the offer must be met with a proper acceptance. Anyway, so now there were things called telexes used into the 90s, which is a bit like a fax really, but it's sent by phone lines. And courts said no, the postal acceptance rule cannot be extended to telexes. And Torres against Miles Far East Corporation, 1955, and Brinky Bourne Limited against Stahag Stahl, 1982, or other cases about this. So you have instant communication by email, fax, basically, it just takes seconds. And there's no postal acceptance rule there. So in JSC, Zestafoni Nicoladze Ferroalloy Plant against Romley Holdings, 2004, and except, as I said, fax is instant. And Thomas against BPE Solicitor, 2010. Sir William Blair, that's brother of Tony Blair, was the judge, and he said obiter dicta that the postal rule is not applicable to contracts that could be formed through sending emails. And a Singaporean court arrived at the same conclusion in Chui Kin Kiong against Digital and Mall Company Private Limited in 2004. So the regulations about the internet are mainly the Electric Commerce Directive Regulations 2002, and they don't say when acceptance is accepted. There's a regulation that says in contracts, a consumer and order and acknowledgement of order are received when the addressee is able to get them. So anyway, so English contract law still doesn't have a case dealing with instant communication. It seems that these can be formed through different ways. Allianz Insurance Company Egypt against Aegeon Insurance Company, Société Anonyme, in 2008 is a case of this. So technology in both these cases was not quite instant. An email, okay, it takes seconds, but sometimes it can take minutes of things going wrong with the internet. And in some areas, in some sort of sections of the economy, the market's moving very fast, and minutes make a difference. So the thing is, do we go by the postal analogy or the receipt rule? It seems that the receipt rule is the one that courts are leaning towards. So, as so often in law, there's no definitive answer. Toodaloo.